Okay, well, it's my pleasure to introduce Keith Ainsworth, class of 87. I thought it was only current day students that doubled and tripled majored, but it started back in the 80s. He was a biology major, an environmental studies major, and an English literature major. And I think his work really embodies that interdisciplinary sort of feature. He is an author of many volumes of poetry. He's a lawyer. He's an outdoorsman, very active in Trouts Unlimited, which is one of the premier conservation organizations in the country. And then in his law work, he does a lot of work with state agencies, with nonprofits, with government, and landowners and land trusts. And he does a lot of local sort of Connecticut litigation and transactions. And I've been talking to him this morning, and the diversity of cases he's taken on is really quite remarkable, and lots of stories that he's going to share with you today. And he is also a proud parent of a Tufts Environmental Studies alum who graduated in 2016. He has another son who didn't come to Tufts, but majored in environmental studies at Middlebury. So that it runs deep in the family, a commitment to the environment. And I'm so pleased to be able to invite you back to share your experiences after having finished one of the very first majors in environmental studies in 1987. Our first major was in 1985. So it's very exciting to have you back. Thank you. And we look forward to your talk.
So, well, thank you. That was very gracious. So I was looking at the topics in the Pope Cunningham series of lectures, and the breadth of subject matter that comes up is just stunning. It really sort of enlightens me as to just the breadth of possibilities where you can go from here. And I knew at the time, actually, back when I was doing the environmental studies program, there were engineers, there were I think a couple of humanities majors, mostly biology majors. And so it was science-based, but you could tell that people had different focuses at the time. And I think that sort of thread has continued in the program, at least from my chats just this morning. And so I'm truly a product of the program, I suppose. Now, after 34 years of practice, I've evolved into the natural evolution of what you would expect from someone who had been an English major doing written and oral expression, and also someone who was a biology major, which is very useful in environmental law. So I'm going to give you fair warning. I'm a litigation attorney. I'm not in business or science, so we don't do slide decks. So there is only going to be a passing coincidence between what you see on the screen and what's coming out of my mouth. And so forgive me for that. And so what I'm going to be talking about today are a number of things. We're going to cover, of course, Tufts ENVS role in my career and where that came from. We're going to talk about just what is private environmental enforcement, which is what I do, and how that differs from other areas of environmental law and other areas of law in general. Then we're also going to talk about where environmental law came from, because it's actually a new area, relatively new area of the law. Most of our law comes from the Middle Ages, and environmental law started pretty much in the 1970s. Then we're going to talk about the public trust and the right to protect the environment, which is really the foundation of what I do, and what you have the right as citizens to be able to do. And of course, that's sort of foundational for environmental law. And then I'm going to give you a few stories of some of the cases that I have handled over time, and touch upon a few of those. And then I'm going to, if I don't run out of time, because I have a time management problem with my slides, we're going to talk about the clash of environmental priorities, and sometimes well-meaning goals can end up clashing internally. And I'll give you a classic example of that, which is the green energy push for solar and wind, and the desire to protect core forest and farmland, prime farmland. And then, of course, we'll have questions and answers. Hopefully, we'll have time for that because I'd really like to be able to hear what you're thinking and be able to address that. So the environmental studies program began when I was a freshman in 1984. And I guess that makes me one of the first graduates. I didn't know that at the time. I thought it had been around for a while. But given the evolution of technology, that was a lifetime ago and a world ago. I mean, I lugged a Commodore 64, that's 64K to college. You had to program it yourself, and technology really hadn't been integrated into a lot of what we did. I think by the time I graduated, there was a primitive connection to the internet. So it gives you a little idea of where we were at the time. But I do recall actually in Dr. Dennett's introduction computer class developing an artificial intelligence program called Give Us a Kiss. It would answer questions as if it were answering you with an intelligence. Very primitive, but so maybe I was ahead of my time. But that leads into the fact that I have fully integrated technology into my practice. My laptop and my cell phone make me completely mobile, and the ability to do legal research online has leveled the playing field in a way that as a solo, I have no other employees in my firm. It is just me. I have an office, but I am the one who handles finding the clients, intaking the clients, processing the cases, and prosecuting them. And that would have been impossible when I started practicing. There were still typing pools when I began practicing. It was throwback to the 1960s where you would dictate something and then someone would go and type it downstairs and bring it back to you. Unthinkable today. Today, everything is processed on a computer. All the research is done. I locate my witnesses. I communicate, texting, emailing, and that makes it possible for an individual to stand toe to toe with the big firms, which you couldn't do when I first started practicing. So, as was mentioned, the connection of Tufts to my career, and they wanted me to touch upon that. Both of my parents actually went to Tufts in the 1950s, and they met here. Obviously, I'm a product of that. And then, of course, my daughter is a product of the fact that I met my wife in the environmental studies program. She's present here, Julie Prescott Ainsworth. And then so my daughter went through this program. So we have some families, like, I guess, horseshoe crabs, their blood runs blue. Well, I think our family runs brown and blue. So the circle of life exists. If I didn't mention it before, my son Spencer went to Middlebury and was also an environmental studies major. So it's kind of like COVID; it gets passed around in the family. So at first, I started out as a biology major, and so I went to Hummingbird Key. This is one of the signature memories I have of the program. At that time, I was pre-med because everybody in my family was health related, and it was kind of expected I'd go in that direction. Of course, I was doing all of my science classes and realized as I got further and further into them that the calculational part was a bit of a challenge for me. But every time I had a class where something involved written expression, I found it easy and I did well at it. So it didn't take a genius to figure out my strength lay in a different direction. So I added my English major as a second major, and I thought that might bring my grade point average up and make me a little more relevant. As I went through that, I started realizing I had an interest in taking environmental courses, or I was interested in the topic. And so I added the environmental studies major in my junior year, or actually late in my sophomore year. And I realized I really enjoyed it. And so in that course of study, I actually had to fit in the courses that I could. Now I had triple major, so I didn't have many choices. I had to fit them in where they fit, time-wise. So environmental law was one of the courses that I was required to take. And I didn't know anything about environmental law. But Gregor McGregor, who was an environmental lawyer in Boston, was teaching the course. And he ended up offering an internship for the program's requirement. And I drafted for him the model wetlands bylaws for the Commonwealth of Massachusetts. That required me to talk to a lot of wetlands agencies throughout the state. And as a result of that internship, he recommended, he said, you seem to have a talent for this. You really should think about going into law. And that was a sort of a real sharp turn away from where I thought I was headed. And, because I was focused on science, I didn't even have an idea what law meant or what it was about. And so literally environmental studies changed my entire trajectory of my career and my life. So there's a lesson there that, a lot of you think that you're here to learn a subject matter, like you're studying French or you're studying engineering or you're studying biology. There is no undergrad course of study that's going to make you an expert in anything because you don't have enough time. In 4 years, you will never become an expert. What you're going to learn as an undergrad is you're going to learn how to teach yourself how to learn about that topic for the rest of your career. And you will eventually become the expert that you hope to become. And it doesn't dawn on you that basically what you're being taught here is to learn how to teach yourself. And so it doesn't matter what topic you're studying, what you're learning is how to think critically, how to write, how to analyze, how to spot issues, and then how to handle them. And so take heart. If you are, in fact, a classics major, you can go in any direction you want. You can go to law. And in fact, if I had to choose a major that would be a good entry into law, it would be philosophy, because they think abstractly, but they analyze things from a rational standpoint, and they argue endlessly. Not that, but anyway, so one of the reasons why I went toward law is because I actually found that I had a strength in written expression. Now, I wasn't good at oral expression. You'll notice I have a slight stutter even today. But for a litigation attorney, it's a liability. But I overcame that because over time, I went to court so many times that I just learned how to speak and advocate because that's what you were required to do. You needed to do it. It was necessity. So understand that your environmental studies major can take you in almost any direction. And certainly that's, I think, one of the lessons I learned here as a classic liberal arts course of study is that what they're teaching you is how to think. I went to law school and they taught me how to think like a lawyer and how to write like a lawyer, how to research like a lawyer. Again, they didn't teach me the law. If you've ever seen a law library, it's thousands and thousands of books on shelves that just go endlessly. There is no way anyone will ever learn them all. What you're learning how to learn is how to know where to start looking for the answer about the question that's been put before you. The client comes in with a question and you say, okay, what's the issue that I need to research to get to the answer? So again, even law school is teaching you how to think about teaching yourself how to get the answer. And so maybe that's perhaps, I don't know if that's an insight you've already come to on your own, but that's something you should think about with regard to your own career. So as I said, the signature memory I have is the Hummingbird Key program, which no longer exists, but Dr. Nick up in the upper left corner and his wife, Joan, were the sort of progenitors of the program and a deep influence on all of us who were in the program at the time. He was someone who really saw no boundaries. When I wanted to add my triple major together and put it together, he was encouraging. Whereas some of the other professors I talked to said, you're way over subscribing. And he said, no, do what you have a passion to do. And I will say that same message to you. If you've got a passion, follow it, because your strengths are where you will be most happy. If you want to enjoy your career, find something you enjoy doing. And I'll just explain. That's me in the center holding a slide, and that's the biological laboratory on the far side, and the interior of the biological lab on the lower left. And it was fairly primitive conditions, but they were doing real science there. In fact, an example of how science can teach you things even when it doesn't work, I was going down to do plankton research. And having come from New England, there's lots of plankton up here. And of course, the Gulf Stream comes up from the Bahamas and ends up here. And so my thesis was that the plankton would be carried up and the population would either be the same or maybe differ, but it would be at least coming up from the Bahamas. Well, as it turns out, Hummingbird Key is on the inside shallows and flats of the Bahamas, where it's low oxygen, high heat, and high salinity, the perfect storm for not a single piece of plankton. So when I got down there about 6 hours into my data collection, I found that there were no plankton, which gave me a lot of time on my hands, resulting in the fact that I met my wife. But the lesson being that even negative data teaches you something, that when my experiment failed, but it taught me that you can come up with a theory, and if you test it, you may not come up with the answer you thought you were coming up with, and that teaches you to then change your approach. That lesson applies across the board in any career. And of course, that's me holding the plankton net that never collected a single plankton. And if you see that the word algae is upside down and backwards, that's only because the flip chart was over. So who am I? What is private environmental enforcement? I went to law school at the University of Miami in 1990, and I began a career in litigation. First in general torts, which is basically slip and fall, car crashes, buildings that burn, people doing bad things to one another. I, of course, wanted to do environmental law, so I had to keep trying to convince the law firm to let me do that. I worked at first a 50-attorney firm and stayed there for about 3 years until their practice collapsed. So I then had to move to another law firm, which was 4 attorneys. Then one of them retired, and it became 3 attorneys. And then another one passed away, so it became 2 attorneys. And then about 21 years later, I broke off to form my own firm. I'm now a solo practitioner. And so I've actually gone from large to micro. However, my practice is not micro. It's fairly busy. I was the past chair of the Connecticut Bar Association's environmental law section, and I was past counsel to Trout Unlimited. And I'm currently the acting chair of the Council on Environmental Quality, which is a state agency that advises the legislature and state agencies on new policies and new laws and changes to environmental law or environmentally related law to make it better than it already is. And so in between all that, I also was mayor of my town as a politician for a couple of years. So I've actually gone the whole range of possibilities that you can be as a lawyer. I've been in policy, I've been in law, and of course litigation. I do some transactional. So it's been a lot of fun, and I will tell you I enjoy it thoroughly. A lot of lawyers are dissatisfied. It's a very intense career. If you're doing it for the money, I will tell you now, go into business. Business has unlimited financial potential, and you can be casual about it. You can be serious about it, but you can do whatever you want. That's the nature of capitalism. But in law, it's very intense, it's very exacting, and it's an unforgiving career. It requires you to be at your best at all times. So if you want to do it, make sure that you want to do it for the right reason. You have to have a passion for right, wrong, and what you're doing. If it's environmental enforcement, you want to be sure that you want to do that, because the intensity of it can wear you down otherwise. So I've been pretty much everything you can be as a lawyer other than retired. Now, the litigation cases that I do, there are lots. I do cases in court. I do appeals in state and federal court. I do agency work, which is where someone's going for a permit, and maybe they're trying to put permit a facility in a bad place. They're trying to put it on top of a wetland or in a park or on top of core forest. And I do opposition work. I'm known as probably the one opposition lawyer in the state that does just that, and makes me very popular among a lot of my colleagues. But in any event, it again is a natural progression. I drafted the model bylaws for the Commonwealth of Massachusetts. Now I enforce the bylaws in the state of Connecticut. For the Council on Environmental Quality, we actually review a lot of the sightings of utilities. And so one of the big issues we have right now are the sightings of utilities for transmission lines. The New England power grid is actually vastly under structured to handle the loads that are required for residential, business, commercial, industrial, and they're having to upgrade those. And of course, when you're doing that, it has an environmental impact. And we are trying to balance that with also energy upgrades for generation, which is solar, wind, and fuel cells. Fuel cells don't have much impact because they're very compact, and they're usually put in industrial areas where it's already impacted. But solar is in particular a problem, and I'll get to that later. So those are the kinds of things that I do. Most of my cases are contested litigation, where I spend my time working up a case, going to court, arguing motions, doing trials, taking depositions, and it's a lot of fun, actually, because it does use science. And I will tell you that some of the best environmental lawyers I know actually have science backgrounds, because they have to be able to talk to the expert witnesses, the engineers, the hydrogeologists, the geologists, the chemists, the civil engineers who talk about stormwater, drainage calculations. Being able to even if I'm not good at making those calculations myself, I can understand what they're talking about when they produce a report and tell them, hey, you need to beef up this section so that I can advocate for that. And so one of the best lawyers I know was an environmental engineer before he came into the law. And so he actually was doing the applications and doing all the calculations. And it's given him a great advantage. However, I don't want to discourage any of you who might want to go into environmental law. Plenty of lawyers come out with probably poli-sci, English, and economics majors are very common. But they have to teach themselves the subject matter that they're involved in. And in fact, I think I've often joked that if you give me 2 hours, I can get up to speed on any case that comes before me, because frankly, it doesn't take that long to figure out the narrow issues that are before you. So it's actually fairly true. Sometimes it takes more time than that, but not always. And actually, for most of the time, it does not. And so the disciplines that you're all studying, again, can lead into law, and especially environmental law if you're looking in that area. So I'm fortunate to have a voice on the policy side of conservation, because what I do generally as a private environmental enforcement lawyer is to enforce individual micro-level cases. An individual versus an individual, a neighbor versus neighbor, someone who's developing a house, an apartment complex, a business, and they're putting it in a wetland, or they're tearing down trees to get a view, and they took those trees off of protected open space for land trusts. And there are special statutes that protect protected open space for municipalities and land trusts, which are nonprofit landholding agencies or nonprofit organizations. And those statutes are very powerful, and those allow me to go to court, get attorney's fees, damages, and provide a serious disincentive for that activity. But I'm going on case by case, individual by individual. It's not the 30,000-foot level that I get to see when I'm doing policy questions about how to tell the legislature, gee, you should plug that loophole on the siting law for solar panels that says if you're between 2 megawatts and 6 megawatts of power, you don't have to do a certain level of analysis for the siting impacts that might occur. And so what we'll say is, geez, if they just change the size of their siting, they can avoid environmental studies impact studies that they need to do. And so we tell the legislature, gee, you need to change the levels of the triggers for environmental law, for example. And that's when I get to think about the greater policy level impacts of the law. So, all right, so put this in here for 2 reasons. One is tomorrow is actually the beaver moon, the beaver supermoon, if you didn't know that. And yes, this poor fellow is kind of an emblematic example of some of the parts of my career. As I was explaining to Professor Oriens earlier, that sometimes a win can be a loss and a loss can be a win. I'll give you an example. There was a 10-year battle I had over the siting of 350 apartment units next to a valuable salt marsh that was the habitat for the salt marsh sparrow that has a diminishing habitat along the coast. It's actually a very narrow band of salt marsh that's the high marsh that's probably only a few yards wide. And because they were siting it near this, they were actually going to damage a significant portion of that habitat. And we lost at every turn. The development pressures were high. The local agencies wanted to see this thing built for the tax revenue. And so we were losing there. The state agency, looking at their subsurface wastewater discharge system, said, we don't look at the other things. We don't look at the birds. We only look at, are they going to meet their capacity for this wastewater treatment? And so everybody was being technical. They had blinders on. Nobody wanted to actually look at the big picture. And so we kept on losing and losing and losing. But after 10 years, 2007 happened. And if you know your history, 2007 was the real estate crisis. And everything snapped. Their financing broke. And even though we lost, we won, because once their financing broke, that property now is a public park in that town, and is now a place where you can walk your dog and see the salt marsh sparrow. So sometimes a loss can be a win. Sometimes a win can be a loss. I did one of the first environmental justice cases in the country, fighting the North Hartford ash landfill expansion, which was creating a lot of asthma problems in the north end of the city of Hartford, which is a socioeconomically disadvantaged community, and a community of color, of course. And the expansion was, of course, going to increase the existing problems with asthma and other adverse health outcomes. And we fought that battle, another 10-year battle. We won. We got a settlement for about $11 million. But as a result of a number of factors, the client actually went through bankruptcy. And as a result of the way the bankruptcy laws were structured, they had to give up their claim to the $11 million. So sometimes a win can be a loss. And actually, in that case, because environmental justice was not the result of a statute that says you must not do this, it was an executive order that says you have to consider environmental justice. We didn't have the kind of legal hook to be able to enforce this. We had to use a lot of public relations, lobbying, and exposure, exposing things to the light to be able to get the ends that we wanted to. So not all of law is simply about going in and saying you violated a bright line standard. Most of law is, in fact, very arguable, as you might imagine. But where there's a statute, you sometimes have a standard where you can say you're either in compliance or you're not in compliance. And so understand that that you have an opportunity to influence what happens simply by using public relations. And in fact, actually last night, I was here at my hotel room when I got the call from my opponent, a very large trash to energy plant that we've been fighting because they've been producing a nuisance noise in the city of Bristol. And they were annoying the neighbors. There was this low hum that goes 24/7, vroom, 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 and it drives people nuts. And I represent the Bristol Burlington Health District, which was enforcing the public health laws. And we drafted notices of violation against the company, and they appealed, and they were trying to challenge our basis for doing that. And last night I got the word that they withdrew those appeals because we exposed that they were manipulating the political process to try to get my client to withdraw their notices of violation. In fact, they got the political forces to try to fire him. And I wrote some very public letters to that effect. Now, last night when I got that word, I was just about to go out to dinner. Here I am with my laptop and my cell phone, putting out a press release to NBC and putting posts on social media, getting those folks fired up, and that gave them a lot of heart to know that their situation might be solved, and it also locked in that the trash energy plant is going to have to continue doing things to improve the situation. So, this is a real career, and it happens every day, all the time. My practice doesn't close. It goes 24/7. It goes on vacations, nights, weekends. Beauty is I can take off time when I need to, but you know, it's exciting and it's dynamic. So I'm going to talk a little bit about the foundations of environmental law. Now, American law comes from, of course, British law, and I'll ask if someone could keep an eye on my time so I don't run too over. I tend to go off in tangents. But American law comes from British law. I mean, we broke off during the Revolution, but we adopted all of the British common law. And their law goes back to the Middle Ages, which is French and even somewhat Roman law. And of course, probably Anglo-Saxon laws that combine in there. But the basis for the law is that the king owned everything. The sovereign owned everything, and we only used it, we the people, we the peasants, used it at their pleasure. And you didn't have a right to enforce it unless it benefited the king. So if someone poached something from your property or trespassed on your property, the only reason why you could file a case against them was because it benefited the king, because frankly, any trespass to you was a trespass to the king. Well, when we had the revolution, of course, we replaced the king with the United States and state sovereign governments. They are now the king. And so that concept of sovereignty still exists. And you only have the right to enforce things that the law allows you to do. The laws are passed by the legislature, which are elected by people. And those laws allow you to do certain things. But environmental law, as I said, only started in about the early 1970s. And so when I went to law school, it was still very new. Most of the laws hadn't even been passed until the late 1970s. And so there weren't people who really called themselves environmental lawyers. They were regulatory lawyers or something else. They converted. And the way environmental law differs from every other part of American law is that it runs counter to the very strong private property rights. America, manifest destiny. It was, you know, from one shore to the other, that we had a right to grab that land and do what we wanted with it. That ethic still exists today. People believe I can do what I want on my property, no matter what the impact. However, as you may have learned in probably your environmental economics course, that's really just a manifestation of the externalization of cost. In other words, I do things that impact the public because I can. An example of that is a factory that's discharging waste into a river. Well, they got rid of their waste. That was a cost that they avoided, but they dumped it into our river, everyone's river, and they've destroyed our fish and the quality of our water that we swim in and would like to have be clean, that we might want to drink. So environmental law basically said, as of the result of Earth Day, which said we've had enough. We didn't want our rivers to set on fire. I mean, there were rivers in the 50s and 60s that actually became flaming waterways, and they were so contaminated that people were getting sick. There were cancer clusters everywhere. And people rose up. They said, no, we want to start the concept of environmental law, which is we, the people, have the right of the public interest to protect our own law. And this came from the concept that's actually medieval in nature in its own right. Now, I'm citing a couple of Connecticut statutes here, but those actually themselves go back to English law. And it's called the charitable trust doctrine. And it was actually a concept that was formed to protect things like a charitable donation to put together a hospital or a home for widows and orphans. It was more the classic charitable trust kind of thing where you're doing something good for people. And the law decided, the parliament and the legislatures decided that's a good thing to protect. And once someone does that, it's protected forever. And so if someone's donated something to the public trust, that is protected forever. Well, the public trust also includes all the other things that are common in nature, like nature itself, water, air, and wildlife. And so that statute was first adopted in Connecticut in 1702 or 1684, and then later in 1702 was modified. But it goes back to 1601, and found the title actually very interesting. It's an act to address the misemployment of lands, goods, stocks of money heretofore given, which is actually the most classical legal word I've ever seen, to certain charitable uses. In which even just coming out of the Middle Ages, the England recognized that things that were in the public interest should be protected. That was the foundation for the Environmental Policy Act. There's two acts that were in tandem, and the Environmental Protection Act of 1971 and the Environmental Policy Act. And these two statutes basically recognized, and I'll read that portion here. It says, the declaration of policy is hereby found and declared that there is a public trust in the air, water, and other natural resources of the state of Connecticut, and that each person is entitled to protection and preservation of the same. And it provided for remedy. This was the first time that a legislature had said, you have the right, all of you are private attorneys general. You have the right to act in the shoes of the sovereign. You are the king of your own natural resources. That was a novel concept, and it's the foundation of all environmental law, that there is a public trust that we all own and we have a right to. Environmental Protection Act gave the remedy. It actually allows you to go in and seek injunctions, which is a court order saying, stop doing that, or do something to fix the thing that you broke, which is a mandatory injunctions and there's prohibitory injunctions. And so these two acts were groundbreaking in the law, and it's the foundation for everything that I do. Other than tort law, which is the ancient concept of trespass. Now, when you think of the word trespass, you think of, I walked on your property. That's the modern definition. But trespass, as in, let's say, the biblical version, that we trespass against thee, that is actually, I have wronged you. And there was a concept in medieval law that if you wrong another, there should be a remedy for it. It would otherwise be inequitable. And that's what founds the basis of tort law, which is nuisance, negligence, the concepts of you've created something that harms someone else and you should be held liable for it and can be held liable for damages for it. So, all right. So the sampling of environmental cases. Now, I don't know if you could read all of these. That's not as much relevant as the ones I'm going to pick out and talk to you about. So one of the good things about being a litigator is you have never-ending basis of stories to tell. I had a case involving the Khmer Rouge's lingering attempts to shut down a Buddhist temple in the United States. One of the few federal cases I took. I won't go into detail on that one because it wasn't environmental, but it was a litigation case that was referred to me. I also had a case involving King George's right arm. And there was a statute during the Revolution of King George on a horse holding a sword. And it was in New York, which was the basis for the Loyalists' operations during the Revolution. And of course, the colonists, being angry, went in there and tore down the statue, broke it apart. And of course, it was made of gilt lead. Lead was, of course, useful in making musket balls. So they took the pieces of it, carried it off back into Connecticut. And the Loyalists found out about this, and they stole the pieces of King George back and buried them in a swamp. And now you're wondering, of course, why is this environmental? It is actually. Because 200 years later, the Wilton Historical Society, inherited a piece of property that they owned, which had an old colonial house on it, and the swamp in which a lot of these materials had ended up by the Loyalists dumping them there. And someone wanted to go in and remove them because apparently pieces of this statue are very valuable. I think in the New York Historical Museum, I think some of these pieces were purchased for $15,000, $50,000, depending on what piece you got. It was the horse's head. King George's head has never been found, by the way. But his right arm, the one that held the sword, apparently was particularly valuable. And they found some writings that said it was buried in this swamp. And someone wanted to go in there, and they asked me, do you need permits to go in and disturb the wetlands to get the arm? And I said, well, it's lead, so you're actually doing improvement to the wetlands. And so, you never know where you're going to go. And it's interesting, by the way, in my research in that case, the courts had determined that the actual ownership of the arm is probably the British government. Even though we claim that it was spoils of war, the British actually owned it at the time, and it was stolen goods. And a little sort of side trip. I also have a number of, I've had suits over the running bamboo, which is a very pernicious bamboo that grows in temperate climates and is very aggressive. It's the only plant that has its own statute. It's that pernicious, that's destructive. It'll go through 2 inches of macadam. It'll go through concrete. It'll tear up your driveway, tear up your sprinkler system, your septic system. It'll take the siding off your house. And it's very expensive to remove. And I've had a number of those suits. Connecticut has a statute that says you can't plant it, and if you maintain it and it goes across the boundary, you're responsible for it. And so when you ask what kind of cases do, I do cases between individuals on individual parcels of property in many instances. I also had a lawsuit attempting to stop the Boy Scouts from selling a bird sanctuary to a developer for putting up housing. Now, the Boy Scouts, as you may have heard, had a plethora of lawsuits over sexual abuse, and they actually went into bankruptcy over this and had 81,000 claims. Now, I don't know if all of them are valid, but certainly many of them are. And the boys, now I was an Eagle Scout, so I actually have a fond memory and respect for what the Scouts stand for. They stand for good citizenship and patriotism, the good kind, not the hyper patriotism that we've kind of seen growing up these days. But they needed to sell off a lot of their properties to pay their share, each of the councils across the country. And some of the Boy Scouts properties are some of the nicest, most beautiful, gorgeous properties because their camps were located on lakes, on waterfronts, in the mountains, beautiful places where you'd want to teach people to, be in the outdoors. And in this case, the Boy Scouts had done something particularly hideous. They actually had a board member who was a developer in New York who wanted to sell this to a developer herself to do the development, but it was really just a ruse to get the environmentalists to pay money to buy it back, and they would pay more money. I mean, that was so that they could use that money to pay off their share of the sexual abuse suits. But there was a bird sanctuary on there where they had accepted several $1 million from a wealthy birder in New Haven, and that created a charitable trust, in my view, because while he hadn't put a restriction on the property as a result, they accepted the money to preserve the place as a bird sanctuary, and they put up a sign with all the birds and the pictures of them and their history, and so I said, no, we're going to file suit. Actually, a friend of mine came in and hired me to do that, and they said, well, no, there's no restrictions on the property. There's nothing in the deed that says it's a bird sanctuary. However, there's a series of cases called the dedication case. If you dedicate something to the public trust and people use it that way, you can actually enforce it that way. It's actually a very interesting theory of the law that that by usage alone, things can be dedicated to public interest. In that case, actually, it's a sad story. They filed a counter suit, a slap suit, and I counter filed a suit against them for violating that. But my client actually said, look, I'm just a guy. I don't want to lose my entire assets fighting a billionaire developer. And we had to back down. I was very disappointed in that because I don't like to lose, especially to people who are unprincipled. But sometimes there are sad stories in environmental law as well. I don't want to make it seem like it's all rosy. I win plenty of my cases, but sometimes there are heartbreaking ones. So just going through some of these other examples, and where are we on time? Oh, all right. Okay, so then in my agency work, I think I mentioned as head of the CEQ that I do a lot of policy work, and we issue an annual report on the healthy environment, and we investigate complaints and advise agencies. So like I said, that gives me a chance to look at the 30,000 foot level. And then I mentioned before, one of the problems with green energy is that solar panels in particular need large spaces and they need flat spaces. Farms are flat areas where the farmer didn't want to plow on a hillside. So unfortunately, farms are being converted to solar. Well, we want to preserve farms because they produce locally grown food, which is a good thing, but we also want green energy, but we don't want to lose one for the other. Now you're trading off one good thing for another good thing, and that's not a good thing. And you're also losing core forest because oftentimes the farmers will clear the forest first as an agricultural activity to harvest the timber, and then they'll put solar panels on the newly cleared area. Now you lose core forest and prime farmland for solar energy. Farmer makes out pretty well, but it doesn't really protect farming. That's one of the things that we grapple with as an agency that I'm working on. But I won't, so I just threw this one in here. And if you can't read what it says on the bottom, it's the frog telling the duck. My lawyer finally got me on the endangered species list. And the joke being, of course, that, hey, look, I've got special protections because there's a lawyer. And, we've just had an election, I think, where a lot of people are dismayed, especially if you're in the environmental conservation space. Don't be dismayed. A friend of mine said, I'm not going to stop fighting just because things changed, politically. And I may go out and hug a lawyer because the law is sort of that last defense. It's a noble profession, and it has the opportunity to do some real good. It's not the answer to everything, but let me tell you, it's a fight worth fighting. So I'll open it up for questions, and I hope I haven't run too long on my.
So if you have a question, I'll happily bring the mic to you.
Thank you for your talk. So my question is about the Supreme Court case earlier this year that overruled Chevron. And I'm interested, and that essentially ended agency deference and gave the courts more power. I'm interested in your legal career and also your work policymaking with the legislature and also the agencies, how that's affected you or how you expect that will affect you. And if not that case particularly, if there are other recent Supreme Court cases that you feel are most noteworthy that have impacted your career.
Sure. So I'm not going to get into the specifics of the cases, but what I'll say is the law changes it. It's an evolutionary thing. It's a living thing. It doesn't stay stagnant for very long. We have opposing forces. We have economic interests that are going in one direction. We have conservation forces going in the other. And hopefully that tug and pull will result in a body of law that makes sense and that balances the various interests. So yes, the law does change, and it does change the balance of power in specific ways. There was a case, the Rapanos case, which changed how you look at wetlands and what is a wetland. And so some things that used to be protected are no longer protected. Those things change over time. They don't change my practice materially. What they may impact is a particular instance. It may be less enforceable. It may be more difficult. It may be easier depending on which way the law is swinging. That's the world I live in. I have to roll with those punches. Everybody does. We are students and children of the law. We obey the law and abide by it because frankly, that's the difference between us and chaos. So yes, the law will change over time, but that's one moment in time over a long trajectory. And so, yes, these decisions may affect a particular case, but it doesn't affect the fact that you're going to go out there and fight those battles regardless. It just means that the rules, have to be looked at in a different way. And sometimes it makes you more creative because sometimes now you have to find a new theory, another theory of the law that allows you to fit into the interstices of where the law may not have thought of going. And I've done that before too. I've come up with novel ways of getting around a statute that I didn't like. It's a lot of fun though.
Thank you. I was wondering on like a similar point, as like federal regulations sort of tend to like go backwards on conservation, especially I'm guessing under new administration, we're seeing less and less protection for the environment. How do you think states can take more of a role in trying to like supersede those regulations and make their own regulations stronger, especially in states like Massachusetts, Connecticut? Like,
okay. So now that raises an interesting philosophy. Our law in the United States has that it's called the theory of federalism. We have the United States government, the federal government, which only has limited jurisdiction. It is a superior jurisdiction. In other words, where it does have authority under the Constitution, it is superior to any of the states. But under the 10th Amendment of the Constitution, those things that are not done by the federal government are left to the states. So under the conservative theory of law, that things should be delegated to the states. That's the abortion question that you probably have heard a lot about, is that it used to be regulated by Roe v. Wade, which was a federal law or a federal case that governed it. And the conservatives said, no, that should be done by the states. They want things to be done by the states, which frankly, there's a philosophy that we've got 50 crucibles of democracy. You've got 50 states that get a chance to do it right. And they all experiment with how to pass laws that protect things or protect interests and create interests. And as each one experiments, other states will then adopt the ones that are best. That philosophy is not inherently wrong. However, it does result in, let's say, injustice in some areas where let's say, a religious influence or an economic interest might overwhelm the best interest of the people. And so in particular states, you might have less just laws. But the benefit to that philosophy is that where the federal government now rolls back its protections under the Commerce Clause, the states can pass their own laws, but only within the four corners, only within the Commonwealth of Massachusetts, Rhode Island, Wyoming, Kansas. And so it's a patchwork at that point. And so depending on where you are, the law might be different. But every state has the opportunity to fix what they think the federal government isn't doing. And there's a benefit to that as well as a detriment. I mean, do you want every state doing something differently? Because the environment respects no political borders. I mean, rivers cross states. And so if one state's protecting and the other one isn't, that doesn't help the river. So from an environmental law standpoint, it is problematic, but there are opportunities to protect things that reside solely within a state.
I'll ask a quick question. So you talked quite persuasively that your internship and your environmental law class, one internship, set your career.
Yeah.
I'm wondering if you have a story or two of interns that you might have had in your career that you've it's been heartwarming to see where they've gone. Like what are the opportunities for our students now in that internship space, and what would you suggest that they look for when they look for an internship?
Okay. Well, as a solo practitioner, as I said, I have no employees and no staff and no associates. So I've only had a few interns, one of whom was a woman who graduated from the Yale School of Forestry, and she's now the director of the Northwest Conservation Land Conservancy, which is a multi-town land trust, and she protects the open space. So that's one of my few interns. The only other intern I had was a very brief, it was a stint with a college student who came in, and I think he went into international trade of some sort. But to be honest, I don't have a lot of interns, because if I spend time teaching them and managing them, I'm not practicing law. The reason why I'm a solo practitioner is because I don't want to have administration. I want to practice law. I don't want to run a law practice. So my suggestion for internships is, if you want to go into NGOs, go find an NGO or non-governmental organization, a nonprofit. Go find one to volunteer with. If you want to go into law, go intern with a law firm, whether it be a small law firm or a big law firm. It doesn't matter. It doesn't even matter what they're doing. It doesn't even have to be environmental law. What you're going to learn is what the law is like, because what you're really trying to do with an internship is decide whether you want to do it. You may get a job offer from it, but your first priority is to yourself. And I mean that not in a selfish way, but you want to figure out what's your passion, what's your strength. And if you're thinking about law, go and see what happens in a law firm, what it's like, because you may find you don't like it. You want to go do something else, but you may find, wow, this is really, really fascinating. And it may end up being what you do. I went from, being a poet and an English major and a biology major, thinking I was going into pre-med, and ended up going into law. I also thought when I went into law that I was going to be in the back room doing deals because I never wanted to go to court. I was terrified of going to court. And now that's all I do. So you don't know where you're going to go until you try it. So don't be afraid to try things. And there are plenty of opportunities. Law firms will take you on. As an undergrad, it's kind of hard because you don't know enough about the law. So you're going to end up doing fairly menial things. As you get into law school, you'll at least have some skills that they may be able to use. But if you know lawyers that you can go and shadow and learn about what it is they do and see what they do on a daily basis, it may give you an idea of whether it's something you want to do.
Well, that's great advice to end on. Please join me in thanking Keith Ainsworth, Esquire,